internship. Okay. So please remember the very first thing which will be requiring in an internship is your typing skills. How many of you know the typing? Not WhatsApp typing, actual typing on the keyboard.
I have, sir, little bit experience. Yeah.
And a basic understanding of the legal formats. Okay. So there are various types of legal notices which a advocate has to send. Okay. And you have to know the legal vocabulary. Okay. So first we have to understand what is notice. So what is notice? Are you able to see the screen?
Yes, sir, I can see.
Notice means as per the Webster's Law Dictionary, notice is defined as a notification or communication of a fact, claim, demand, or proceedings. Now, first I will be explaining you the very basic concept of notice, and then I'll show you one of the notice which was sent for check bounce. Okay. Now, as per just a general meaning of notice is a notification or communication of a fact, claim, demand, or proceedings. This is a general meaning. But when you come to the law, you have to be very clear. And where notice is defined in our law, the term notice is defined under section 3 of Transfer of Property Act. So you will be getting this Transfer of Property Act in semester 3. But you should know where a notice is
గల్లబోయి పడుతుంది. నీళ్ళు వస్తలేవు ఇంట్లో,
now.
నీళ్ళు వస్తలేవు. మార్క్స్ వస్తుంది మరి, ఈడ కూడా అట్నే వస్తుంది.
బ్రో మ్యూట్ లో పెట్టుకోండి బ్రో మీరు.
So section 3 of the Transfer of Property defines notice. What is notice? Can anybody read what is notice? Slowly, so that everyone can understand.
A person is said to have a notice of a fact when he actually knows the fact.
When he actually
Or
knows the fact, or
when, but for willful abstention from an inquiry or search which
will,
he ought to have made.
which he ought to have made, or
Gross negligence, you would have known it.
gross negligence. Right. Now, what is legal notice as per the law definition?
Basically, fact
When a person knows the fact, when a person
or yeah,
knows the fact, or when, but for willful abstention, money you are not doing something. It is omission. Willful abstention means even you know it, you're not doing that. Okay. Writing a check when you know that there is no money in your account can be called as willful, wantedly, from an inquiry or search which he ought to have made, or gross negligence. He would have known it. So understood what is notice? Notice is the short form of notification or communication. Please one thing of fact, claim, demand, or proceeding. And if you know the statutory definition of notice is given under section 3 of Transfer of Property Act, which says a person is said to have a notice when he actually knows the fact, or when, but for the willful abstention. What is the abstention? When you are not doing something which you should be doing, from an inquiry or such which he ought to have made, or gross negligence. He would have known it. So, do you have any doubts still here? What is notice? General meaning? Hello.
sir, sentence looks a little bit difficult to understand, but as a simple terms you said, right? General meaning, I can like fact. That's what I can fact or
It,
search or inquiry. Yeah.
it
Yeah.
is fact, claim, demand, or proceeding. It simply means that you know something. Okay. You know something. It is knowledge. But you are not acting on that knowledge. If you know that there is notification that you should, what you know that when you are giving a check, you should, before giving a check, you should check that whether some money or amount is there in your account or not, right? But if you issue the check without knowing that whether money is there or not, and you're issuing the check and the check gets bounced, then what is that? That is your willful act of gross negligence. And you know that there is no amount in your account, it also comes under the notice, right? Understood? Any doubts still here? Prashant,
No, sir, I
Nath,
can
Soumya
understand.
Gaud, Renu,
Yes,
Sudha.
sir, I got it.
Okay, so this was the basic general meaning and the statutory definition of notice, right? Next. Now, what are the types of notices? What are the types of notices? Can anybody read?
Someone else please read because everyone active participation is required. Please.
Yes, yes.
Actual notice is a notice that is given directly to a party or is personal received by a party, informing them of a case that would affect their interests.
So, what is that? There are two types of notices. One is actual notice. The other one is what is the second?
Contract to notice.
It is constructive notice. One is actual notice. The other one is constructive notice. Now, what is actual notice? Actual notice is a notice that is given directly to a party or is personally received by a party, informing them of a case that could affect their interest. So, I'll be sharing one of the so let us see the constructive notice, then I'll share one of the notice. What is constructive notice? Please read the constructive notice.
Sudhakar sir, please read or anyone else.
So you have to know the terms. That's why I'm asking you to read. Because when
Constructive notice or employed notice may be defined to be knowledge which the court imputes to a person from the circumstances of the case upon a legal presumption so strong that it cannot be allowed to be refuted, that the knowledge must be exist, though it may not have been formally communicated.
so constructive notice is a constructive notice or implied. Constructive notice is also known as implied notice. Money it has to be understood. Implied money understood by understood. May be defined as the knowledge which the court imputes to a person from the circumstance of the case. Now, when there is a criminal case, you file a criminal case and the case goes to the court. What does the court issue? What does the court issue? Court issues summons to the defendants to be present on the particular date and time. So it is sent by what? Court only. Knowledge which the court imputes to a person. When the court sends notices, they are called as summons. They are called as summons. From the circumstance of the case upon a legal presumption so strong that it cannot be allowed to be rebutted. The knowledge must exist through, though it may not have been formally communicated. Now, how many of you have got notices or you have seen notices coming to your relatives or friends?
Sir, one notice, defamation notice we received from my mother-in-law, and
Yes. It is sent by court
and
or
we
it is
also
sent by lawyer.
advocate, sir.
It is sent by advocate. That is the actual notice. That is
Okay.
the actual notice. When it is directly sent to a person, by person to person, it is the actual notice. How many of you have got the notice from courts? When the notice is given by the courts to come and appear. How many of you have seen that it is called a summons? There are very summons.
I
Summons
have
are issued.
seen it. I have seen it in one of my family members. They received the summons from the court. I think that is in 498.
So, and if they are not present there, it has to be, they have to know it, whether it is officially communicated or not. If to the person whom the notice is given and they are not present, what happens? One time or two time or three times?
Court,
The fourth time will the court
court,
issue a arrest warrant. Then you have to file a recall petition. The court will issue the arrest warrant. Then if you want to cancel it out, then you have to file a recall petition, giving some medical excuse or whatever genuine excuse, and then you have to cancel that petition, cancel that warrant. So actual notice is something which is sent personally and received by the party personally, informing about the case, right? Now, what is constructive notice? Constructive notice is sent by the court itself. Understood this point? Actual notice and constructive notice?
yes, sir.
Yes, sir.
Yes, sir.
Difference between
These
notice
both
and
notices are to all cases, sir, civil and criminal.
No, देखिए, our civil case starts with a notice. Civil
Okay.
case starts with a notice. Criminal case starts with FIR.
Okay.
Criminal case starts with a complaint. Complaint is converted into FIR, and then it will go to the court, charge sheet.
Yeah.
Notice
Okay.
is for the civil case. Civil case, notice is sent, and then a plaint will be drawn based on notice. Right? The thing is
Okay.
next. Now, understood what are the types of notices?
Yeah.
Then, objectives of notice. Now, as the court, so what is the objective? Objective. Mane, what is the goal of sending a notice? So please read.
Procedural law.
Yes, please read.
Procedural law is intended to facilitate and not to obstruct the course of substantive justice. Provisions relating to pleadings in civil cases are meant to give to each side intimation of the case of the other so that it may be met to enable courts to determine what is really at issue between the parties and to prevent deviation from the course which litigation on particular causes must take.
Now we are learning this. The notice is the first step in our civil law. Our civil law is based on the civil procedure code, right? Now, as a civil procedure code is a procedural law, in one of the case, the court gave this observation. It says in a Ganesh Trading Company versus Moji Ram case, it is 1978. Now, the notice is one of the first step in a procedural law. Now, procedural law is intended. What is my intended? The goal, the objective, the intention is to facilitate and to not to obstruct the substantive justice. Now, what is my substantive justice? if you have done something and the court will take the cognizance and will make the wrong right, that is substantive justice. Now, when you go to the court, how much time the case will run in the courts with your experience?
20 years, 10 years.
20 years and 10 years. Now, if you directly go to the court and say file a case, the other person doesn't know whether the case is filed against him or not. He comes after some time and says, I don't know, sir, that this case was filed. So what happens? There will be waste of time. That's why whenever you are filing a plaint, the court will ask, before filing the plaint, the court will ask whether notice was given or not. Please read this. Please read this underline part.
Side intimation of the case.
It is a side intimation, money giving the notice, giving the information of the case so that the courts can say, okay, some information was given to the other person who is said to be allegedly guilty. So whether sufficient time was given or not to give the answer. If I send a notice to anyone and it says that within 15 days, my client is facing this problem. Within 15 days, you solve it. Otherwise, we'll go to court. A chance was given to the, what you can say, the other party to correct the wrong. If the other party doesn't correct it, then the case will go on. The notice will become the plaint. Okay, the plaint will go to the written statement. Then the whole process, 10 to 15 steps are there. So understood this point? What is the objective of the notice? To give each side intimation of the case. You send a notice, the other party will also reply the notice. When one of the parties is not satisfied, they'll go to the court. Okay. Any doubt here?
No.
No, sir.
Okay. Shall I go to the next slide?
Yes.
Now, drafting of notice. Please read.
Sudhara ma'am, someone else please read. I think Soumya, Sudhakar, me
Drafting of
already read.
notice. How will you start drafting of notice? Please read.
Drafting of notice is governed by the general principle of drafting of pleadings.
General principles of drafting of pleadings. Okay. Next.
Order V1 Rule 1 of CPC says that every pleading shall contain only a statement in a concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved and shall.
So, drafting of notice is governed by the general principles of drafting of pleadings. So it is governed by what is the general principles of? What is governed by which principles? Drafting of pleadings. Drafting of pleadings. Whatever the documents you will give in writing to the court in the civil case, they are called as
శైలజ
pleadings.
గారు కొంచెం మ్యూట్కి వెళ్తారా?
Okay.
Sir, if possible, mute, sir. From your end.
Yes, I have noted. Okay. So it is the general principle drafting of pleadings. Now it is order 6. When you have the civil procedure code, there is a book called Civil Procedure Code 1908. As per the order 6, rule 1 of the Civil Procedure Code says that every pleading should contain the same to same. You can take it for notice. Okay. What you should do? You should not give any evidence. You should not give any evidence. You should write only the facts. Right? In a concise form, a very, very abstract form, in a summarized form, and of the material facts relies for which claim or defense, or the case may be, but not the evidence by which they are to be proved and shall. Okay. Please, when necessary, be divided into paragraphs, numbered consecutively, dates, sums, and numbers shall be expressed in figures. Okay. Okay. So it is the drafting of notice is governed by general principle of pleadings. It should contain only facts in a very, very summarized form with material facts only. And if the notice is long, lengthy, it should be divided into paragraphs, numbered consecutively, dates, sums, and numbers expressed in figures. Understood this point? Any doubts still here? You should not give any evidence. You should just take the facts. Evidence is
No,
given in
sir.
the court. Shall I move to the next slide?
Yes, sir.
Yes, sir.
Okay. Next. Now there are style of drafting. There are the style of drafting. Now this style of drafting is called inverted pyramid style of drafting. Now what is the inverted pyramid? Mane, first when you see the size of this, you can see that the top portion is broad, right? Then the middle portion is slightly lesser than the top portion, and third is the conclusion part. So are you able to see the slides?
Yes, sir.
Please read the first part.
Most important information.
The very first part should contain the most important information about the dispute or legal injury. ठीक है? Second क्या है? What is the second one? What is second part should contain? Hello. The second part should contain what? Anyone can read? Hello.
Sir, are you able to hear me?
Yes, but anyone should read or I should read?
No, sir. Somewhere read actually. She read actually. I think there was a disconnect.
There was no voice. Did
Yeah,
Shailaja read?
Somewhere, I think. Yeah.
Relevant information, substanting the important information.
So the second part should contain the relevant information substantiating the first part. One is supporting the first part. Okay, first most important information, then supporting the first part. Third part shall contain the consequences, results of ignoring the notice or its implications. Okay, if you neglect this notice, we'll go to the court under the relevant law. You should make like this part. The first part is very most important information. Second part is supporting the information. Third part is making the other person know that if you do not act on this, you will feel the consequences. Okay. Next. Now, elements of drafting. Draft a notice in simple plain English. Now, when you are drafting, you should not be you should not use high language, high words. You should be very simple and plain English. Present tense. Avoid using legal jargons and maxims. Do not show your legal aptitude or legal vocabulary in notice. You should exhibit it in a court. But when you're writing, it should be very clear. Understood? Second,
Yes,
make
sir.
short sentences. Do not
Sir,
make
legal jargons means
legal vocabulary. If I say, for example, if I start using the word, what you can say? If I say the word like pro forma defendant, pro forma petition. What do you mean the pro forma defendant? Did you understand what did I say? Pro forma plaint or pro forma defendant. Who is pro forma defendant? Did you understand this?
No, sir.
No. That is
No,
legal.
Prashant. Yeah, Prashant, what I got is like when we are sending notice to someone, right? They don't know legal terms. So if we send like
Even,
yeah, that is
even the lawyers don't know what is pro forma defendant. Sometimes lawyer doesn't know. So you should not use the
like
legal vocabulary, high legal vocabulary. Just use simple English. That's all.
yeah, sir. In first semester we had to be juries, something like magazines,
be
those and all. Yeah,
like
if we just
in
be
thoughts,
repeating.
you be just ibi remedium,
yeah.
injuria sine damnum, damnum sine injuria. You cannot, even the lawyer doesn't know, even the student doesn't know. So how the other person will know? Okay. This you should avoid. Second is short sentences only. You should, legal jargon technically means no much technical words. Use simple words, that's all. Making short sentences. You should make the sentence very short so that it can be understood very clearly. What is the third one? Address the name of the parties by name rather than as noticee or respondent. Address them directly. Understood?
Okay.
When you are writing the plaint, then you should make in your when you are drafting agreements, the parties will be given as the transferee or transferor. When you are giving on what you can say, you will use that other names like noticee, respondent, plaintiff, appellant. But in notice, it should be the direct name. Understood?
Yes,
These are
sir.
the three elements of drafting. Example of notice. When you say example of notice, general notice in civil suit. See, civil suits, money come, you need to file, what you can say, you need to say that please deter from doing this thing. That is civil suits. Cease and desist money, stop and go away. Notice. Stop and go away notice. Third is arbitration notice. Money, please come and talk. Before going to the court, let us decide the case in out of court only. That is arbitration notice under the Arbitration Act 1996. Then you will have most common notices are under section 138 of the Negotiable Instrument Act, which I will show you one of the example. Okay. And other is etc. Other types of notice. I will give you the different formats of the notice. Don't worry. Okay? Any doubt in the examples of notices? Then, any doubts still here?
No, sir.
No, sir.
No, sir.
Now, I'll give you one example of under section 138 notice. Okay. Now, please remember what are the pyramid of the notice?
Most
Important information will be the first part.
Important information. Now please remember
Yes.
important information money. The very first thing. Now I have drafted one notice for my, what you can say, for one of my client. Now, first you should write your name, advocate, address for correspondence. If you have a letterhead, it's okay. If you don't have your letterhead, you have to write it by your own hands. You have to draft it. Are you able to see the screen here?
Yes, sir.
Yes, sir.
So this is my name, my degree, advocate. What is the address for correspondence? Then you have to write registered post acknowledgement due. You will be sending the notice by post, right? So you have to write the registered post acknowledgement due. Then you write the date in the terms of date, month and year. Then to whom you are sending. First you should write to whom you are sending. I was sending this to Muhammad Abdul Haseeb Hazar, son of, I am not writing as respondent or plaintiff or any legal words. I'm just writing as to whom Muhammad Abdul Haseeb Hazar, son of Sattar, residence of so and so address. Understood this point? In the direct language.
Yes, sir.
Then here, after this two, you have to write the statutory notice under section 138 of the Negotiable Instrument Act. Clear a point? Yes or no?
Yes, sir.
Now, this I have written here. This is the, what you can say, I have made it in the paragraph forms, right? So, I'll be taking this example of this legal notice. After, just take a minute of 1 or 2 minutes as a break. Please log in with the same link. Okay, I'm just ending this this session here. After 2 to 3 minutes, please log in with the same link. I'll go through the contents of the notice. Okay.
Okay, sir.
Just
Sir,
log in within
actually, sir, 40 minutes team meetings will extend,
Yes.
right? You might need to create new one, or you are
No.
premium membership.
This is premium one. This is 40 minutes only. You can use the same
Okay, then fine, sir.
same link. Just 1 minute. I'll send you this
Okay,
notice
sir, thank you.
in the PDF in the group. You can read it in that way, and I'll also go through the contents of the notice for you. Please, after 1 minute, please log in with the same link.
Okay, sir.
Okay.